Good afternoon. Welcome to the meeting of the Bills Committee on Employment Amendment Bill 2022. This is our second meeting. It's time and we have a quorum. Now, attending the meeting today from the administration, we have Mr. Chris Sun, Commissioner for Labor, Mr. Raymond Leung, Assistant Commissioner for Labor, Mr. Ma Kwok Kun, Chief Labor Officer, Labor Relations of the Labor Department, Ms. Françoise Lam, Senior Assistant Law Draftsman of the Department of Justice, and also Mr. Anderson Chan, Government Counsel of the Department of Justice. If I may first remind members, as you attend the remote meeting, you must use the virtual background of Zoom of the assigned color, and please keep the video on and show your faces while you're attending the meeting. And for those attending meeting, you have to attend this meeting remotely at a location in Hong Kong. And also, when your speaking time is about to be up, 15 minutes before that, the staff members will display a timer of Zoom on the screen, and then when your time is up, there will be a beeping alert. Part 1, meeting with the administration. On the submissions and the response of the administration, according to our discussion at the meeting on the 7th of April, the Secretariat published a notice on the electrical website to invite written submissions. We've also informed the 18 district councils, as at 5 p.m. on the 13th of April, the Secretariat received 43 submissions on the bill, and then also on the 19th of April, the Secretary received another 28 submissions. That's after the deadline, and that's all the submissions are in paper number CB bracket 2227/2022-01. That is actually the administration's response to all the submissions. It is an updated version. I will first invite Mr. Chris Sun, the Commissioner for Labor, to take us through the consolidated reply, and to allow for orderly arrangement for members to speak. I will first invite the staff to clear all the raised hand indications. And after the indications are clear, now can I invite members who wish to speak to use the raise hand feature of Zoom to so indicate. If I may also go to matters arising from the last meeting, follow-up to issues arising from previous meeting. That's paper number CB bracket 2227/2022 record order. There's a list of follow-up actions, and then administration is giving response in paper number CB bracket 2227/2022 bracket 03. And then Dr. Kennedy Wong and Mr. MNU sent a joint letter in paper number CB bracket 2216/2022 bracket 01. Then the administrations gave a reply in paper number CB bracket 4227/2022 bracket 04. Now I'll first invite Mr. Chris Sun to take us through the two sets of responses. Thank you. At the last meeting on the 7th of April, members raised a number of issues and asking us to follow up on them. And we would like to give a response to the Bills Committee. And I will briefly go through the various issues. First item, it was asked last time if employers could ask employees to show their visit records on the Leave Home Safe app during quarantine. Now that's not a requirement, but then the Privacy Commissioner issued a guidelines that is the guidance for employers on collection and use of personal data of employees during COVID-19 pandemic. That's and so employers could ask for information in relation to under the guidance. But then in the guidance, it states that under the epidemic, we want to safeguard the health of employees and employers. So data users, if they collect health status in relation to COVID-19 that could be regarded as legitimate purpose for the data collection. But then the employees may still comply with the guidance. That is for information or health information not relevant to COVID-19, they should not be collected. So the principles and so on are spelled out in the guidance. And I ask members to refer to that guidance. And then last time there's a question on, how we define close contact. Now, according to the relevant website, it says that in general, close contact means family members living with the confirmed patient. 2, those who have face-to-face close contact with the confirmed patient, especially when when the confirmed patient is not wearing a mask, like they have a meal together. And then 3rd point, during the 5th wave of the epidemic, a member asked that about the number of labor claims relating to the 5th wave of the epidemic. Now, in the 1st quarter this year, the Labor Relations Division handled consultations and written inquiries when members asked how many. And the 1st quarter of 2022, we handled 9,457 consultations as face-to-face consultation and 6,143 written inquiries covering all sorts of questions. Now, so we have sorted out the inquiries and consultation, found that there are definitely 7 employment claims relating to COVID-19 concerning termination, wage dispute, and variation of employment terms. So we had to provide conciliation service. Of these 7 cases, 6 were resolved upon conciliation, and the remaining claim was referred to the Labor Tribunal for adjudication. And then members also asked about the proposed new section 32 KB to the employment ordinance. And if that is if an employer requests an employee to produce vaccination record, and if the employee does not do so, then the employer may dismiss the employee, and that is not considered as unreasonable dismissal. So it has to do, so this has, and then the question is about whether the new section 32 KB would constitute, would be a violation of discrimination, disability discrimination ordinance. Now, so as we explained, with this dismissal, we'll make sure there is a proper legal basis, there's a due process and so on. So we believe, therefore, it won't constitute a disability discrimination. We have set out the reasons in detail in the paper. And then members also asked if an employer requires an employee to take vaccination, to be vaccinated, and if there's any adverse event, would there be any legal liability on the part of the employer? The short question is no, because the employer is not the manufacturer or the supplier of the COVID-19 vaccine, and the employer is not responsible for administering the vaccine. So therefore, it has nothing to do with the employers. And also, the government has set up an indemnity fund for adverse events following immunization and coronavirus disease 2019 vaccines. If unfortunately there's any serious adverse events associated with COVID-19 vaccines, then it's covered by the indemnity fund. Now, members also asked us to look at other communal jurisdictions, whether they have legislation similar to the proposed new section 32 KB. Singapore has a similar legal requirement. Singapore requires all employees to be vaccinated from the 15th of January 2022 onwards before they can return to the workplace. If employees do not do so, then the employers may redeploy the unvaccinated employees to suitable jobs. Or arrangement could be made for no pay leave for the employees on mutual agreement. And if after exploring all available options, an employer may eventually terminate the employment contract and is not considered as a wrongful dismissal, which is the same as our unreasonable dismissal. And then other members suggested we produce a concise guide for the public to understand the amendment details. We've done that. It's annexed to the response. So you see that this is a concise guide. So it's easy for members of the public and employers to follow the amendment content. So we've prepared this table, as you could see. Now, finally, whether there will be financial imposed on SMEs and labor-intensive industries was this a set of amendments. But as we mentioned last time, the government is giving support, say, through the anti-epidemic fund and the employment support scheme. In fact, the employment support scheme was just endorsed by the Finance Committee. So the scheme will come into effect, and then all affected trades will be given assistance and support. So that's our consolidated reply to members' questions. Shall I pause here, or shall I go on to the other paper? Okay. First, Mr. Lai Tong Kwok. Yes, Mr. Lai Tong Kwok. Madam Chair, I have a number of questions. How much time do I have? 4 minutes each, including questions and answers. Last time, Ms. Carmen Ken asked about the new section 32 KB, and if it's may violate the disability discrimination ordinance. The administration gave a long explanation as to why it won't violate that ordinance. But then what the government has not said is that this does it fit with the definition of disability in the first place, with because if it doesn't meet the definition of disability, the disability discrimination ordinance, of course, does not apply, and the administration has not addressed that point. Second point, now if employers ask employees to get vaccinated, will they become legally liable in case of an adverse effect? The government said in general, it won't be, it would be unlikely, but it would be unlikely then generally, but what would be the special circumstances where it will become likely? And a concise guide, while I'm grateful to the administration for responding so quickly and coming up with this concise guide. But then on Amendment 3, I have some questions. It says here there will be a sunset clause when the pandemic is under control and vaccination is no longer a matter of grave public health concern, then the amendment will be repealed. Now, I have studied the entire bill. Firstly, I don't see the existence of a sunset provision, which we usually know. We just say that there is a certain clauses that will come into effect, and that clauses may then repeal certain provisions. That's how it's done. So that is a totally different approach to a sunset provision to which we are familiar. I've done some research, and I'll tell you what is a sunset clause. Again, this is not in this bill. So this so-called sunset clause here, I really have doubts about it. I would like some explanation from the administration. And then when we come to clause by clause scrutiny, then I will further elaborate on that point. Thank you.
Thank you, Chair Lady, and thank you, Mr. Lai. 3 questions here. We have reviewed that letter would constitute disability discrimination under DDO for the new section 32 KB. We have explained the main grounds. I'll see if the DOJ counsel would like to supplement. Well, you mentioned we'll talk about the definition of the disability. Well, we usually consider whether the employee's request is legitimate, and also will be any reasonable exemption requirements in making this decision. Second, as if the if according to section 32 KB, if employer asks the employee to show proof of vaccination for any adverse events after vaccination, will the employees be legally liable? As explained in the response, we don't think that the employees are held liable. Well, it's just generally speaking. Well, this is a secure way of saying that, well, for any unknown scenarios, we can't be totally sure. The government takes a conservative approach that employees don't need to be legally liable. If the employer is not the manufacturer or the supplier or the one administering the vaccine, so we have explained. I think Mr. Lai meant by that we have a provision that when the pandemic is over, that will be repealed. The way repealed that the Labor Commissioner will specify the specific date that the relevant provisions will lapse. So this we call it a sunset provision. We understand, Mr. Lai, that, well, I don't have a legal background. I suppose that the law draftsman can explain. According to the dictionary definition, will it have the same meaning as the sunset clause, or you want to be absolutely correct? I suppose we can quote unquote sunset, so that this clause will not be permanent. If necessary, we will repeal it or let it expire. For details, I'll let the law draftsman explain. Ms. Francois Lam, can you briefly explain? Thank you, Mr. Lai's question. There are 2 points. First, the DDO and what's the relationship with a justifiable vaccination request. Under DDO, the core object is not due to disability that the person will have a different treatment than someone without disability. For the 32 KB, the main safeguards in making the vaccination request need to consider the job nature and the actual operational requirements to making the request justifiable. Within the company, well, on 32 KB bracket 2, for the same job or very similar jobs, that is not issued a vaccination request instead of single a particular employee. For the sunset clause, we understand Mr. Lai's explanation of the sunset clause. Well, on the strict definition of the sunset, we need to make it clear, make it explicit that this ordinance will lapse on a certain date. I suppose that's the most proper way to draft a sunset clause. Well, as an explanatory document, since the sunset clause does not appear in our bill, the restriction received related to the 32 KB vaccination requests. These provisions, when the pandemic is over and when the Labor Commissioner deemed at the right time, they will repeal that section, which would achieve a similar effect of a sunset clause. Well, how do we explain beyond the legal context? I suppose that the Labor Department can reconsider. Well, I suppose we can save this for the second round, shall we? Let me read out the list of members. Mr. Dennis Leung, Mr. Carmen Kong, Ms. Sunny Chan, Mr. Lam Chan-Shing, Mr. Lee Jin Cheng, and Doreen Kong. Mr. Dennis Leung. Thank you, Chair Lady. Well, amid the fifth wave, the FGO had dealt with over 300 call for assistance to obtain the quarantine or the isolation order. I hope that the commissioner and hope to address the issue I outlined. Looking at the paper CB 2202 and 03 on para 3, explain the definition of the close contact. There are two types. Well, first, live-in family members, and two, those who had face-to-face close contacts with a confirmed case, especially when the case did not wear a mask. For example, having meals together. For some of the call for assistance, especially those working as security guard at the Sunny Bay, they were confirmed while working, and some of the employees were classified as close contacts. Well, since they were infected by their colleagues at work, and yet the employer classified them as close contacts. On para 3, it did not explain that you could be a close contact while at work. We don't have anyone from DH. I hope that the Labor Commission can explain this. Well, for those who are infected on duty, they'd also be classified as close contacts. Well, the penny-based security guards were infected while on duty. Well, should they be classified as injured on duty or just treat them as ordinary confirmed cases? Two questions, Commissioner, please. Thank you, Chair Lady, and thank you, Mr. Lau. Well, I can't answer, I give it authoritative answer on behalf of DH. Well, in our response, we outlined the general circumstances. Well, if the DH defined those working at the Sunny Bay as close contacts, well, this involves professional judgments and the guidelines. I suppose there will be no ambiguity about this. But the second question, if someone come down with COVID due to work, he or she can seek our help. If they consider themselves as infected on duty and see that as an occupational disease, and some of our colleagues are dealing with people working in cleaning as security guards and from all walks of life, they blame their infection due to work. They see that as an occupational disease and therefore should be entitled to the OD compensation. So far, we have dealt with 500 or 600 of those similar requests. And some of them managed to reconcile, some that require further adjudication or mediations. For the cases you mentioned, let's say they work as security guards and see that they blame the infection due to be on duty, they can come to the Labor Department without the consent of the employers. We will help them. We will contact the employers and whether both sides can forge a consensus. If the disagreement, then they will take it up the next step. If both sides cannot come to an agreement, if we need to get to the court or tribunal to settle the matter. Of the many cases we came across after mediation from the Labor Department and after weighing in the professional advice, for most complaints, both sides can come to an agreement. Next, Ms. Carmen Can. Thank you, Chair Lady, and thank you, Commissioner. Just now you mentioned, well, we'll discuss on the bracket 01 paper. I think the Commissioner was explaining the government's response. I suppose we can ask questions on both documents, shall we? Well, you can start first. Commissioner, well, in your response to 01. We have received over 40 submissions since the 7th April meeting. I've went through all of them. As for whether we should provide for the retrospective effect, the government claims that it would involve complicated legal principles and technical problems. Well, for the public knowledge, but it doesn't mean that I agreed that we should have retrospective effect. Now that we have the DOJ reps here, why retrospectivity would involve complicated legal principles and technical problems? First question. And second, and for the 03 paper on the PDP, the Privacy Commission issued the guidance. The last time Mr. Sunny Tan asked that whether the employer can require employees to produce the leave home safe records. I suppose the answer was quite ambiguous. Well, quote, individual employees who have inquiries about PDPO may seek assistance from the PCPD, quote. Can you elaborate that whether the leave home safe records or health related data? In order to understand the health status of an employee, would that be a reasonable request? Health data. Well, in the concise guide, well, the public is quite well as the sick leave should start at the quarantine order, and if those were 2 doses on the 7th day, if they have conducted RAT 2 consecutive negative results, we'll see as the end of the quarantine period. So that well, if the employee did not proactively inform the employer of the end of the quarantine period, can the employer check the employee leave home safe records and whether they had gone out? And whether they were fully quarantined for 14 days, or they only obtained 7 days of sick leave after having 2 successive RT tests. The employers will need to have a clear guidance. A third question on the 509 requirements on table 11. I suppose I waited for the clause by clause. Just now, well, the commissioner hasn't quite covered the 3 scenarios. I suppose I shall wait till clause by clause. The fourth question, and the applicability of the vaccine pass in the concise guide on Amendment 3, that what constitutes not considered unreasonable dismissal. Let's say there are 3 types of female employees, and for the vaccine pass premises, for example, restaurants, beauty parlors, the pregnant women will not be exempted. And for the government imposed requirement or recommends to get vaccinated, for example, the elderly homes and public hospitals, the pregnant women working in those premises will not get exempted. For example, well, for the vaccine pass at exempt premises, let's say the general offices, let's say a white collar pregnant worker or lactating, and in your table, they could be exempted. Can the commissioner explain why there are 3 scenarios for pregnant women with different treatment? And will it confuse the employers? Can I ask the pregnant employee to produce a vaccine pass? It seems that only in the 3rd scenario that the pregnant employees can enjoy the exemption. I will stop here.
Short reply first, Commissioner. Perhaps You could answer the other questions while you answer other members' points. Yes, I'll ask the law draftsman to supplement in a moment. Many asked why there couldn't be a retrospective effect for this bill. Well, last time when we discussed the matter, we've made it rather clear. Here we're talking about hundreds of thousands of employers and millions of employees. So when employers make any decision, they would, under normal circumstances, refer to existing legislation in making a decision. And then if when they see a new bill with retrospective effect, it would be very confusing to employers, because at the moment when they made the decision, they did not break the law, but then afterwards they find that the bill has retrospective effect and they've actually broken the law, and it will cause undue concerns. It will be really complex. That's why every time when we propose amendments, usually the amendments will come into operation on the date of Gazetto. And then people will know exactly that when they make a certain decision, it's not against the existing law. But then if there is a retrospective effect, they wouldn't know when the retrospective period starts, and it will be very confusing to them. So that's why we have to handle this really carefully. With any legislative amendment, we have to be careful, and everyone must know the exact date when the amendments come into operation. So perhaps the law draftsman could supplement further. Second point, could we say a bit more on the Fishery Commissioner's guidance? Well, we are not the authority on privacy, but then on the 15th of May, the Commissioner issued a guidance which is rather clear. So you could refer to that in detail. And you asked which parts of the guidance are relevant or applicable. For example, in the guidance, what I see is, say, can an employer collect temperature measurements, travel histories, vaccination records, COVID-19 test results, infection records, and so on. So you see, this is like Q&A or FAQs. That is, if employers have to fulfill the statutory duty to ensure the health and safety at work, then they could ask for such information. But of course, there are no final details as to whether the employer could ask to see the leave home safe records of employees. Now, it doesn't come to such fine details, but the general principles is there. And if you want to ask about such more finer details, maybe you have to seek explanation from the commissioner, who is the authority. But of course, in the guidance, many details are covered. It says here, because there are new arrangements, and if employees have had 2 doses of vaccine, and on day 6 and day 7 there are 2 consecutive RAT negative result, then the isolation order is deemed to have ended. So if therefore sick leave should no longer apply after that. Of course, employers may be worried that employees won't do the test on day 6, day 7, or even if they've done the test, they won't inform the employers. Then I think with this guidance of the Privacy Commissioner, it could help employers to allay their concerns as far as possible. Third question is really well put by Ms. Carmen Ken. New section 32 KB or Amendment 3 in the concise guide. Why do we want to include the table? It's exactly because we know that vaccine pass is a measure of the government to fight the epidemic. And under the vaccine pass, there are various exemption arrangements. And there is a clear provision that you have to have a valid medical exemption certificate before someone could be exempted from the vaccine pass arrangement. So therefore, we cannot override the vaccine pass arrangement with the employment ordinance. That's why when we amend the employment ordinance, for all arrangements and exemptions under the vaccine pass arrangement, we follow them in our amendments. In other words, We have not taken out, in the vaccine pass arrangement, pregnant women are not singled out. Now, if anyone wants exemption from the vaccine pass, the only way is for them to obtain a medical exemption certificate, and we have no choice but to follow this requirement. And for type 3, that is for premises where the vaccine pass are not applicable, we're telling employers that if you want employees to produce vaccination proof, then here there's room for us to do a bit more in relation to the exemption. And after some discussion, it was agreed that for pregnant women, there should be a specific exemption arrangement. That's why we have included that here. So we're talking about premises where the vaccine pass is not applicable. That means if someone is a pregnant woman, that is a form of exemption. So I hope with this explanation, we could better follow why we are proposing this amendment. Thank you. Next, Mr. Sunny Tan. Madam Chair. Second round, please, because you have, exceeded your time limit by good measure. Mr. Sunny Tan. It's really frustrating. As Ms. Carmen Ken mentioned, with regard to the Leave Home Safe app. So please give logical reply and explain the arrangement to us. Because for us employers, we, for quarantined colleagues or infected colleagues, we are forced to accept that they could make self-declaration, but then employers want more assurance to ascertain these genuine cases. With Leave Home Safe app, we just want to confirm one thing that's not there. It's as straightforward as that. So shouldn't you, fight for this on behalf of employers because it's worth doing and it makes common sense. If so, then we see what we can do. We could seek legal advice. We could have, refer to the privacy ordinance and see what we can do. Because I've read the ordinance again to say that under certain circumstances there could be exemption, blah blah blah. What I'm saying is, we just want to confirm one thing that has not happened. Are we, collecting additional personal data? No. If that person is sick and hasn't gone out, then it's fine. And we're not asking for any more information. So can you not spell it out clearly in the bill? What are the risks if we could check people's Leave Home Safe app? Do you follow what I'm saying? And then you could ask the law draftsman to do certain things. Of course, no one wants to be held responsible, so we're just passing the buck to other departments. But the point is, how big an issue it is, or can you just give assurance to employers to say that, well, the government fully follows what you need, so we support you, and even you check employees Leave Home Safe app is not a problem, but because you could check that, so employees won't cheat. That's all it's about. So I hope that the department could explain that. Commissioner. Thank you, Madam Chair. Thank you, Mr. Sunny Tan. About whether employers have the power to check the Leave Home Safe records of employees. Well, that isn't covered by this bill, actually. Here we're talking about under the Personal Data Privacy Ordinance, whether employers could ask to see the records. And our bill cannot really override the powers of the Privacy Commissioner to allow that or disallow that. But then, as I said, the Privacy Commissioner has issued a guidance, particularly in relation to COVID-19. And the guidance spells out the circumstances under which health data could be collected in relation to the fight against the epidemic without violating privacy. For example, checking closed circuit TV information or seeking autopus card information is allowed, but we just have to make sure that the collection of data is in accordance with the law, and there's a legal basis for that. Of course, I follow Mr. Sunny Tan's point. Let's say there's an employee who's had 2 doses of vaccine, and you want to know whether the employee has done rapid antigen test on day 6 and day 7, and if the test results are negative, if that's the case, that means the employee could actually go back to work. But then you worry that some employees may not be so honest. So if you wonder if checking Leave Home Safe app would help employers in that sense. But then in the guidance, the Privacy Commissioner does not come down to such fine details. But in any case, we'll go back. The Labor Department will inquire with the Office of the Privacy Commissioner for personal data, and we'll see if employers asked to see the Leave Home Safe records of employees, would it be a breach of the relevant ordinance? So we'll ask for advice from the Privacy Commissioner, and then we will come back to members. I think that is a more proper way to deal with it, because we cannot deal with it in the context of the bill, but we could seek the information instead of asking you to make the inquiry. So perhaps we could, on your behalf, ask for advice from the Privacy Commissioner. Shall we do that? Just a quick response, Madam Chair. Thank you very much, Commissioner. Now, if you are not going to propose amendments under the bill, then please seek the legal opinion in relation to the guidance on behalf of employers. I have no objection to that. So I'll wait for your follow-up reply then. Commissioner, perhaps under the ordinance, what employers could check and what they can't. Together, you could issue a strike statement of the Privacy Commissioner. Yes, we'll seek the advice of the Privacy Commissioner, and then we will issue a reply to this Bills Committee. Thank you. Next, Mr. Lam Chen Singh. Thank you. Sorry, we can't hear you, Mr. Lam. You have to repeat your questions. Can you hear me now? Yes, please. Thank you, Commissioner. I have 2 questions. One, it's the same concern as Mr. Lai Tong Kwok about the sunset clause. Is it the case that when the Commissioner for Labor is satisfied that the pandemic is under control and vaccination is no longer a matter of grave public health concern, then the Commissioner for Labor could decide to repeal the amendment? There is no need to go through any procedure, say through the Legislative Council or moving further amendments to the ordinance and so on. So I want you to explain that more clearly. Second point, I've read the submissions we've received. One is from this labor union on cleaning workers. That is, say if employees are put under a compulsory quarantine and then the employees are dismissed, then it will not be considered it will be considered a reasonable dismissal. But unreasonable dismissal is not the same as unlawful dismissal according to the ordinance. Unreasonable dismissal that the employee must be employed under continuous contract for no less than 24 weeks. But as for unreasonable or unlawful dismissal, the compensation could be more, not exceeding $150,000. And also for the reinstatement arrangement is also slightly different, because for, say, unreasonable dismissal, if the labor tribunal eventually rules that the employee should be reinstated, then the views of the employers and employees must be sought. But for unlawful dismissal, that's this compulsory reinstatement order. if the labor tribunal believes that the employee should be reinstated with good grounds, then there is no need to have regard to the wish of the employer, and then reinstatement order could be issued right away. So therefore, unreasonable dismissal and unlawful dismissal is different according to the law. So how come now here is it just mentions unreasonable dismissal? Thank you.
And thank you, Mr. Lam. Let's call it the sunset clause for the time being. Well, just about the commissioner repeal the relevant provision, and our paper will explain that when will the commissioner repeal the vaccines provisions when the COVID-19 is deemed no longer as a pandemic, then the commissioner will use his powers to repeal. So that's a two-step. First, we need to wait for the health authorities to declare the pandemic is over or reduce or to no longer a threat. Then the Labor Commissioner will then repeal the vaccination requirement. Second, once this is repealed, whether you need to go through LegCo, actually we have to, this is a subsidiary legislation which is passed by negative vetting. So we will also submit another subsidiary legislation to LegCo for deliberation. Second, Mr. Lam raised a good question. Under EO, there are two types of dismissal. First, the unreasonable dismissal, and then the unlawful dismissal. I'll let Mr. Raymond Liang to explain the difference of the two. Thank you, Mr. Lam's questions. Mr. Lam stated very clearly, under the EO, there are the unreasonable and unlawful dismissals. Why this amendment bill only cover the unreasonable grounds? For this round of amendments, we did not change the structural framework of the EO. Under the EO, a sickness day or a sickness allowance are two different concepts. In some case, that could be a sick day, but however, they may not be entitled to a sickness allowance. For example, it's less than 4 days, or he or she didn't accumulate enough sick leaves. If an employee, after the bill's passage, that during quarantine or isolation and the time spent regarded as a sick days, whether they are entitled to the allowance is a different matter. Assuming the same employee is entitled to sickness allowance, in this case, if the employer decides to dismiss he or she anyway, and due to the absence from work caused by the CAT 599, and based on the EO requirement, this will become an unlawful dismissal. Like in this case, like Mr. Lam said, it is both unreasonable and unlawful dismissal that the employee can seek more compensation than out dismissal, for example, as termination of payment or compensation, or ask for a reinstatement. Well, that have to be adjudicated by the labor tribunal, and that's my response. Next, Mr. Michael Lee. Thank you, Chair Lady. I have quite a few questions. I want to know why the Commission didn't ask the PCPD and the DH to come along today. Well, a lot of members asked about the PDPO and the depth classification of a close contact. A lot of employers complain about the close contact definition as well. Thank you to the departments for launching the concise guide. Well, for having meals together, do they have to be on the same table or in the same restaurant? Very often, the employees do takeaways or lunch boxes in the offices if they have meals in the same office, or are they all close contacts? I hope the commissioner can clarify. And for those sick leave sheet, let's say for the RET on 6 or 7 days, it has been reported that someone used soft drinks or juices or rice wine to dupe the RET to produce a false positive results. How can we prevent that? I said at the last meeting, well, if you ask me whether we can check the leave home safe, well, I don't think it's likely. The DH, once the people upload the results, it will conduct a sampling spot checks. Can the employee ask the DH to conduct spot checks for them? Doing some spot checks will serve as a strong enough deterrent to prevent this sick leave cheats. So 2 questions for now. I will say for another round. Thank you. Commissioner? Thank you, Mr. Lee. And how to define close contact? This is a professional assessment. The health authorities must look at the circumstances before calling as close contact. And the Labor Department is not in a position to answer, and we can't really give a general answer. Well, you can't answer, you should bring the DH rep along. We're now in a gray zone. So how do we define a close contact? Nobody knows. Well, having meals together. Let's say both persons took off their mask, have meals in a meeting room without close contacts. How about in a different room? Mr. Lee, can you let Mr. Sun to answer? Well, let's hear from him if DH can answer your questions. Thank you, Chair Lady and Mr. Lee. Under what circumstances are people considered close contact? It's a professional judgment. We need to leave to the health authorities. Mr. Lee is concerned whether some employee will cheat sick leaves. It has reported that the Department of Health had this confirmation mechanism that on the RT declaration platform, if you report a false positive result, the police had already made arrest. And for those who want to fake the RT results and in the hope of obtaining sick leaves, this should be a very strong, stern warning. This illustrated that the DH spot check mechanism and the police follow-up is a very powerful warning. With such strong deterrent, I don't think any employees would dare try breaking the law just for a few sick days. If arrested, there will be a huge price to pay. And yesterday's news told us that the spot check mechanism is strict and is working. If anyone found to upload a fake result, there will be serious consequences. Once again, I remind all the employees, if you are infected, of course, you need to declare online and get your sick leaves. However, if you fabricate results to obtain results, there will be huge to pay, and we will definitely catch you. Next, Mr. Rin Kong. On the government's response in the 03 paper, I wish to say 2 things and seek further clarification. And for 32 KB, but the employee's request the employee to get vaccinated whether constitute discrimination. The government claimed that whether it's discrimination, there are 4 factors. First, that whether the employee request is justifiable. And 2, what is reasonably necessary to protect public health. And third, for vaccination to be made, the employer must consider the employee's work and the operation requirement. And the employee should reasonably believe that if the employee contracted specified disease, there will be a risk of infection from being exposed. I suppose this is very complicated, a four-step process. Well, if you need to follow 32 KB to request vaccination, and if cannot have a clear-cut position, the provision would give rise to litigation. If we are aware of this gray zone before the passage of this bill, can the government issue a more detailed explanation to dispel the employer's concerns, and also to preempt any future court cases? As for whether any common law jurisdiction introduce provisions similar to 32 KB. When I asked the question at the first meeting, I found it quite strange. On compulsory vaccination, the government has not been firm enough. We're asking the employers to issue a mandatory vaccination request. This is even more challenging. And Section 32 KB really led to human rights issues covered by the basic law. I've conducted some desktop research. I hope that the administration can explain that in the government's response, he cited the Singapore example. Singapore has not legislated for vaccination. It only issued advisory guidelines. And for vaccinated employees, it's just 2% of this population. Well, there's a stark contrast to Hong Kong. In the guidelines, the unvaccinated employees can choose to work from home or switch jobs or even the no pay leave. The Singapore guidelines did not offer an iris fits approach. Well, it's just issue guidelines by having the government employ employees voluntary contribution to achieve the protection barrier effect. Well, for the drafting under 32 KB, I'm quite disappointed. To draft a provision, you need to do your research and properly, and should not legislate for the sake of it. If Hong Kong becomes the first city to legislate on this matter, there should be a thorough discussion to understand the rationale behind it before implementing. The commissioner mentioned that we had to be on a secure footing. If we cannot explain the legal consequence on 32 KB nor its uncertainty, and how could you ask the legislature for support? I hope the administration can clarify. Thank you. Commissioner, will you or the law draftsman will take the question? Commissioner, will you or the draftsman take the question? I'll see if Ms. Francois Lam can supplement from a legal perspective, and I will answer from the policy perspective. Ms. Lam, and thank you, Chair Lady. From the legal level, the employer has given a quite clear explanation. I have no supplement at this point. Commissioner, thank you, Ms. Kong's question. And the way 30 KB is written is not the employer forcing the employees to get vaccinated. Well, let's break it down into two parts. For part one is the vaccine pass. When the vaccine pass applies, that if the staff cannot fulfill the requirement of the pass, then they cannot report to duty. Then on this ground that the employer will dismiss this, it's just made it clear in this bill that it's not unreasonable dismissal. This was discussed last time. Even we don't amend the law under the EO framework for the general provisions, the employer can interpret it this way. For any dispute, they will need to go to the library tribunal for adjudication. We hope that as a lady employers worry that what they do would not lead to unreasonable dismissal. And well, another scenario covered would, let's say, the general office where the vaccine pass is are not applicable. Well, if the employer hope to encourage vaccination, let's say if during this procedure and we ask the employees to show vaccination proof, this is also a safe way. We've discussed with DOJ for some time. There should be a notice period, and you cannot single a particular employee. Then you should issue the notice to everyone. When go ahead, if the employer refuses to vaccinate it, well, the infection risk will be enormous to those who work around him or her or expose the customers. I must stress that we're not forcing vaccinations. I'm talking about the employer are given this power to ask the employee to produce a vaccination proof. When the vaccine pass does not apply, the employee can only show a proof of 1 dose. The employer cannot stipulate how many doses the employee must take. At the policy level, we see that as feasible, and we've discussed it with the DOJ, and we see that it's feasible and legally sound before including this. Next, Mr. Yan Menu.
Thank you, Madam Chair. At the last meeting, we asked the Labor Department a question. Grassroots workers issued with some isolation and quarantine order. Some employers insisted they must produce leaves, a medical certificate to be granted sick leave. And last time we asked for some figures, and the Labor Department told us that in the first quarter there were just 7 cases of employment claims related to the COVID-19 epidemic that involved conciliation. So 6 cases been resolved. 1 case will be referred to the Labor Tribunal. The government claims that if there are no isolation order, employees will be granted sick leave, and if they encounter any problems, they could approach the Labor Department. But with this very serious wave of epidemic outbreak, the Labor Department has only handled 7 labor disputes, and I find it strange and disappointing too. Even my office has received more than 7 cases seeking assistance. So, and then you won't consider retrospective effect for the bill. So how can you help those who were made to take no pay leave because of isolation or quarantine order? How would you deal with them? Because they have already taken no pay leave. Commissioner. Thank you, Madam Chair. Thank you, Mr. An. We mentioned that we received thousands of inquiries and consultations. But if it comes to an actual claim, there's a higher threshold. And according to record, we've handled 7 claims. But then colleagues told us that more often people just call and ask about the latest arrangement. So we've issued, the Labor Department has issued a guidance. That is, if employees have isolation order, there's no need to produce a medical certificate, and sick leave could be granted. But so note that, Commissioner, I asked the same question last time. How many calls did you receive? You don't have any statistics. You say for cases seeking assistance in relation to the epidemic, there were just 7. Now, if you have figures as to how many calls were received in relation to the epidemic, then do you have the figures? Tell us. Commissioner, I don't think Mr. An is very happy with your reply. Yes, I see the member is not happy, but then we actually have not made record of the telephone inquiries in relation to the epidemic. We don't have such breakdown, because usually people, when they call, they have a host of questions. And these are just some phone calls making general inquiries, and that's why we don't have such detailed records. If where we have detailed records are with cases of dispute, and so that's why we have the figure of 7. Of course, we want to do better, but in terms of records. Mr. An, my question is, are you going to help those people? You say the bill won't have retrospective effect, but then here, these people, maybe they're not confirmed cases, they are just close contact or secondary close contact because of isolation or a quarantine order. They were made to take no pay leave. Now you appeal for them to approach you. Other than that, how would you help them? Commissioner, thank you. Now, in the guidance we issued, that is, if you have an isolation order, that means you're a confirmed case, and then the employer says that you have to get a medical certificate. Well, then we have made it clear that if as long as an isolation has been issued, then the without a medical certificate, then the employer must grant sick leave. But if both parties could not reach a consensus, they could approach the Labor Department for assistance. So if you have a quarantine order, that means you're not a confirmed case and you're just a close contact. It's true under the existing legislation, you cannot be granted sick leave, and that's why we think there's need to amend the employment ordinance so we could make it clear that whether it's an isolation order or a quarantine order, the sick leave could be granted. Mr. Yang Wing-kit. I would like to follow up on paper bracket 3. Now, many in the grassroots sector actually have more than one jobs, you know, and then according to the amendment, if you have an isolation or quarantine order and you're under continuous contract, then you could be granted sick leave. But the thing is, what if the person has several part-time jobs? Could the person enjoy sick leave from all these employers? If so, if the employers know that they are long-term part-time staff or you know, they have multiple part-time jobs, would they lead to any labor dispute? Because the bill cannot address these as complicated cases. Because, you know, say the employee could, if there is a sick leave certificate, then the employee could just produce the certificate and get sick leave. But now with the amendment bill, it cannot deal with similar scenarios. So how are we going to deal with such disputes in future? Commissioner. Thank you, Ms. Yung. The bill does not amend any criteria for getting sick leave. These criteria include continuous contract of no less than 24 months. The sick leave is 4 days or more, and so on. So all these criteria have not changed in relation. So we're not changing the existing framework. We're just saying that under the existing framework, if you have an isolation or a quarantine order, then there's no need for a sick leave medical certificate. You only need to produce this isolation order or quarantine order issued by the health authorities, whether it's in paper based on electronic form, then it's acceptable. Now, I think you've got me wrong. And what I'm saying is that if you just produce the isolation order, you say that this is a kind of certificate for paid sick leave. What if someone has many part-time jobs and then he can use this order to get paid sick leave from company A, company B, company C, and company D? Then that's a gray area. I'm not talking about the existing paid sick leave arrangement. Commissioner, can you explain that? Well, that shouldn't happen. We're talking about continuous contract. If you have many part-time jobs, then it's not a continuous contract. Commissioner, there are many people who take up several jobs. One in the morning, which is a contract job, and then in the evening, they have another contract job, or they even have 3 contract jobs. There are such cases in reality. Perhaps the Assistant Commissioner could answer your question. Now, as the Commissioner explained, in this amendment bill, we are not changing the framework under the employment ordinance. So one important aspect is what constitutes employment. Now, let's say an employee works for the same employer for 4 weeks or more continuously, and each week the working hours are no less than 18, then that's a continuous contract. And then Mr. Yang referred to the employment status of some workers. They have either long-term part-time staff, or they have many part-time jobs. Now, it doesn't matter if the employment status fits this 418 criteria, that is a continuous contract, then they will be protected. So you're saying that if they have an isolation order, then they could get paid sick leave from all their different employers. Is that the case? Yes. Well, because the amendment's not changing, the original framework of the employment ordinance has always been the criterion. Let's say if someone works for different employers, it's the case for each job, it fits the requirement of 418 continuous contract. If so, then it's fine. But so it really depends on the employment status of the for us to make it to decide. Next, Mr. Peter Shiu. Thank you. Now, the commissioner mentioned media reports today about 3 cases of sick leave cheats. First, I would like to thank the commissioner and his colleagues for doing this random checks. Because in the business sector, many are worried. In this epic pandemic, many are trying to exploit the loopholes in the law to cheat on sick leave. Now, businesses are already struggling with the pandemic. If they don't have, they're already short of staff, and if people take sick leave, then they will be further short of staff. And I have explained this at the first meeting to the commissioner, as businesses are worried that employees may use fake RT18 positive result. But anyway, so you say that you're going to be doing more random checks, and we certainly support that. I hope you will actually do that. Second point, many would like clarification. Now, this bill has not yet commenced. We're still discussing it. I understand there won't be retrospective effect, right? Retrospective effect, yes, that's right. No retrospective effect. Is that true? No, there isn't any. No retrospective effect. Okay, then. Let's say this bill comes into operation. Mr. Lee Chan-Kern mentioned a point. That is, employers may suspect that the condition is not true. And then if they inform you inform the department, then you could do a check. You say you considered last time. So what's your decision now? Who are you putting this question to, Mr. Likely or the commissioner? Well, Mr. Likely has already asked questions, but anyway, doesn't matter. I'll ask the commissioner to reply to your 2 questions. Thank you. Yes, yesterday there were 3 cases because of fake declaration, false declaration, and those 3 were prosecuted. So that's a good warning. Now, if employers suspect foul play, then could the Department of Health do checks on behalf of employers? Now, we've talked to the Department of Health. There's already established system for random checks, so it's not possible to make checks in response to employers' requests. That would be difficult. In any case, the whole checking system is stringent. That's why we saw 3 cases yesterday. So we have to rely on the Department of Health to do random checks. But of course, as I said last time, if employers are really worried, I understand there are private companies in the market to do another test for the employees at their homes. So this won't be a legal requirement. It will be a matter of company policy. For the 3 cases reported yesterday, you kept advising people not to, break the law. What would be the most serious consequence? Commissioner. That's not law under the Labor Department, so I don't have the details, but definitely that would be a fraud or deception. Okay, 10 members have asked questions the first round. 3 others would like to ask questions in the second round. The first one, Mr. Lito Cox, second, Ms. Carmen Ken, and then Mr. Michael Lee. Thank you.
Let's have 3 minutes per member. First question. The government administration did not answer my question on the disability discrimination. For the definition of disability under DDO, is unvaccinated fits the definition of disability. Well, if the Labor Department cannot give an answer, please supplement in writing later. For the sunset clause, I must point out, and for section 1 and 3 on the commencement date have empowered the commissioner to repeal 32 KB, 68B, and Schedule 12, and to repeal legal provisions involving Articles 73 on bracket 1. Only legislature can have the constitutional power to repeal legal provisions. This is a serious question. When we enter clause by clause, we'll raise it again. Hope that the administration can go for an extra mile to reduce this kind of inconsistency. And for the written submissions, they mentioned that for a business being suspended or the employee need to get quarantined or isolated, will they be entitled to a sickness allowance? The Labor Department gave a very vague answer and asked both sides to negotiate. We need a clear answer, yes or no. And especially for the scheduled premises suspended. We lost you briefly. You lost your sound. Can you hear me now? Yes. Can you hear my last point? Can you repeat? On the third point, a lot of submissions mentioned that for the suspended scheduled premises and for the employees under no pay leave, if they're infected or become close contacts, they need to undergo quarantine or isolation. And for this period, after the bill's passage, would they be entitled to sickness allowance? The LD did not answer and only asked both sides to negotiate. We need a clear answer, yes or no, and why. And finally, and for the Ms. Kong's comment on 32 KB, it is so complicated in working. This put a lot of pressure to the employers that you need to have a reasonable, a justifiable request and so on. Most employees won't know how to handle it. I suppose I would save it for clause by clause. Commissioner? Thank you, Chair Lady. Thank you, Mr. Lai. For the first one, I will reply in writing on the disability matter. And for the second question at the clause by clause, I will wait for Mr. Lai's comment. And third, that for the suspended scheduled premises, I think Mr. Lai is referring to if the worker is already on no pay leave after the bill's passage, that for a worker already on no pay leave, if they're infected or isolated, would they get any sickness allowance? The answer is no. It's covered by current provisions. Well, they're not paid in any way during this period. Therefore, they need to pay any sick leave and so on. After the bill's passage, that has been agreed that this is a no pay period for whatever reason, and infected or isolated, the employer don't need to pay anything. And it's been outlined on point number 6 in our response. I know the employees care about this. Well, that's the same arrangement as in the past and in the future. Can the commissioner make it clear in writing? so that we have something to follow. Well, it's been mentioned on the consolidated response point 6. Next, Ms. Carmen Can. Oh, hang on. And for the 3 amendment items, after listening to so many members, only amendment 2, that for the restriction of movement due to Cap 599 for as unreasonable dismissal as relatively free from controversial. Amendment 1 and 3 are very controversial. What are we discussing? That nobody wants to get COVID. Well, for the movement restrictions or quarantine or isolation, who is in the best position to pick up the tab and face the risk? That's what the members are facing with discussing our policy. The commissioner claimed that we'll talk about legal principle. I disagree. This is an administrative decision. Well, the government is not showing the costs of the sick leaves, and well, you're simply transferring the burden to the employer. Well, this includes retrospectivity. This is not complex legal principles. Well, for the red moratorium, that make it retrospective from the 1st of January. That, well, for the start of the protection period, that the landlord cannot chase the rent. Well, we can have a similar treatment for the sickness days as well. We are discussing something very controversial. And for the unreasonable and unlawful dismissal, had to do with the amendment item 3, that for the 32 KB, Mr. Lai and Ms. Kong discussed at length. For the vaccine pass, you're equating that with the capability to work. The under 32K, that if somebody vaccinated or not, you see it as a reasonable request. But yes, as a part of the job capability, a job competence. And for section 15, if we cannot terminate a pregnant employee, that would be unlawful dismissal. Between unreasonable and unlawful, can you explain to us? There are 3 types of pregnant women. Which type of pregnant women would constitute a reasonable and lawful dismissal? For section 15, and when would it be override? Well, I think you need to explain. I have other questions during class per class. Commissioner, please. Thank you, Ms. Kan. Under the EO, well, for the absent from duty, it's the employer's duty to pay for this sickness days. Well, absent due to sickness, well, of course, the employer pick up the tab. We're talking deemed as sickness days. Well, this is not illness. I suppose an isolation is related to illness. Well, the quarantine, those people aren't sick, and mandatory testing isn't sickness. For those movement or restricted due to mandatory testing or quarantine, they don't have the medical certificate. Well, we have to acknowledge that they are not sick, and now we are deeming them as sickness days. Commissioner, thank you, Ms. Kan. On point 2, we're expanding the definition of sickness days. That under Cap 599, well, due to the isolation order or the quarantine order, or the restricted movement with a period more than 4 days, they would deem as a sick leaves. It's always been the spirit of the. If there's something beyond their control that prevents them going to work, it's the same as sickness days. That under these circumstances, we should treat it give the same treatment as sickness days. That's the spirit of the EO. That should also be the employee's obligation. This principle has not been changed, and that's the object of this bill. Second, Ms. Kent raised a very salient question. I'll let Mr. Raymond Lang to explain that under the EO, there are two types of dismissal. First, unlawful dismissal. And second, unreasonable dismissal. Indeed, it's quite complicated. If I explain orally, we can produce a comparison table. Well, we demonstrate the difference between unlawful and unreasonable dismissal. There are different scenarios that trigger them. Let's say a pregnant employee, if it's terminated by the employer under the EO, this is an unlawful dismissal. But with the introduction of the vaccine pass, if the vaccine is not a vaccine pass premises and employees see that capable of doing this work and decide to terminate her under the new arrangement, this would not be constituted as unlawful dismissal, but is still an unreasonable dismissal. Well, that will fall under S15 of the EO. We produced this table. It's quite complicated for the oral explanation. Well, I'll show you when is it unlawful and when is it unreasonable dismission. That we are well aware of this. Well, we didn't say that the employee must terminate an employee. 32 KB is not telling the employees to fire a certain staff. If the employer ran other options and could accommodate the employee, well, instead to terminate him, they will discharge the employee the liability of unlawful dismissal. However, well, that you can't really enforce the unlawful dismissal. So on this, I suppose after the meeting, I can produce a comparison table, as this is a very detailed information. Well, I suppose you can prepare this comparison tables before the meeting, so that we can ask more targeted questions. Next, Mr. Michael Lee. For the amendment item 3 in the concise guide, that the employees may make a written notice to all employees of the same or similar job nature with not less than 56 days. How do you come up with 56 days? Why not 48 or 42 days? First question there. Second, I have a technical query. Let's say an employee is unvaccinated and the boss has given a 56-day notice, and on the 55th or the 54th day became a close contact, and the 56 days, if he or she is not vaccinated, can the employer terminate this employee? I just want the employer or everyone has a better idea. I just want to know what's the difference before or after 56 days. Commissioner. Well, we need to draw a line which should be long enough to get the staff vaccinated. Therefore, we see the 8 weeks as sufficient. However, is it the absolute standard? Well, no. I suppose we can argue 48 days. We hope to make it long enough. Well, usually they need to make a booking and need to make time for it. I suppose the 8 weeks should be more than enough. That's our standpoint. That's not absolutely scientific. However, we see that as reasonably enough. The second question. 54, 55th day, can the employer terminate the staff? I don't think it's relevant. For 56 days, that under the EO amendment bill, if the employers ask the staff to produce vaccination proof, they need to give a minimum period of 56 days notice. If after 56 days, the staff has a duty to show the vaccination proof, that's not a contradictory. let's say someone decided to get vaccinated on the 55th day, however, he was infected that day. Well, you can discuss with the employer. Let's say he's reluctant to be vaccinated, but unfortunately he came down with COVID. As an employee, I can't dismiss him, or as a close contact, as he's unvaccinated, can I terminate him? Well, this is a hypothetical question. We're not encouraging the employer to invoke this provision to dismiss employees. This is wrong. If there's a practical need, or if on the 56 days and he cannot produce a proof of vaccination, however, it's coincidence that he becomes a close contact or serving a quarantine order, then we need to see them both together. After the bill is passed, he is entitled to sickness days. If you terminate during the sickness days, that's unlawful dismissal. Under EO, there are so many divisions. There may be some uncertainty. However, we can address it. The main point is about a mutual understanding. While nobody asking the boss to fire on the 57th day, the quarantine is only 14 days. After 14 days, if you still cannot produce a vaccination proof, but then you can dismiss him. That's not unreasonable nor unlawful.
Next, Ms. Doreen Kong. Thank you, Madam Chair, for allowing me to ask questions. Commissioner, I want to say something in all fairness to employees. Now, you say that the Section 32K does not compel employers to make employees get vaccinated, but you know that's a suspicious argument. If people don't get vaccinated, they will lose their job. So why is it not forcing employees to get vaccinated? It's not the same as vaccine bubble. Let's say if I'm not vaccinated at most, I won't go to that particular restaurant, or I just I just cook at home. But now you're telling employees to lose their job, so that's a serious matter. And then with this amendment to employment ordinance, with any employment ordinance issued about promoting the labor relations, is not about adding to conflicts between employers and employees. So with amendments 1 and 3, it seems that you are just you know, giving the hard decision to employers. And I agree with Ms. Carmen Ken and Mr. Lai Hong Kwok. They raised some legal issues. That is, even if people are not sick, you consider that sick leave, or if someone is not vaccinated, then the person is regarded to be incompetent. Now, this is not really desirable. And then Ms. Lai also mentioned such provision. Hong Kong is a metropolitan city, so if we make any laws, there has to be a good basis. We can't just because if we amend any legislation, it will affect multinational companies. So we have to be very stringent in the way we amend legislation. And please don't give us the reply so late, because we only received the administration's response last night. Commissioner, thank you. For Section 32KB, it really is the case that we are not asking employers to dismiss staff. But then you appreciate this. We're having a serious epidemic, and vaccination is one of the most important means to fight the epidemic. So we have to consider various incentives to encourage people to get vaccinated. In fact, there's been a strong voice in the community. Apart from vaccine pass, what if employers want to play their part, but then they're worried if employees won't get vaccinated? What can employers do? So if they want to mandate everyone in the company to get vaccinated, but what if some staff refuse to do that? It will lead to disputes, and that's why we are proposing this amendment. If employers want to make their contribution in the fight against the epidemic, and the best way to do that is to ask their staff members to get vaccinated. So most get vaccinated, but a handful refuse to do so. Then there has to be certain measures that the employers could take, and so they could dismiss the staff and they would not be regarded as a unreasonable dismissal. It's not about, you know, fueling conflicts between employers and employees. I've asked international companies if they want to do that, and many tell us that they want to do it, but they worried if there is no legal backing whether they could do so. And so that's why we're going to amend the legislation. If we have this amendment, then if even for multinational companies, they want to encourage colleagues to get vaccinated, they don't need to be worried. I know, I fully appreciate Ms. Kong's point, but you know, we're in this stage of the epidemic. We all want to do something. So with Section 32 KB, you should look at it from the angle of fighting the epidemic. Because we want to make it clear in the employment ordinance. Because we're asking employers to join us in the fight against the epidemic, but then they're worried about such gray areas, and so they're not able to help. So that's why the government has to make a choice here. And our choice is that we put fighting the epidemic first. So we want to encourage employees to get vaccinated. And when we do so, we need to make sure there are sufficient provisions so to prevent, you know, unreasonable staff members from targeting their employers and so on. And we want to make sure there are sufficient protection clauses. And it's about striking a balance, of course, and we have to listen to members' views as to what is the best, the right balance. We know it's not easy, it's tough. When we first first drafted Section 32 KB, we talked to the Department of Justice. We know it's not easy because here there are conflicting values among people. But then as a government, we need to make a choice. So our choice is, because we want to fight the pandemic, so we have to make this very clear in the law. So I just want to explain what we went through in our mind as we came up with this amendment. But of course, if there's room for improvement, we will listen to your views to make the improvement. So together, the community could fight the pandemic together. Of course, any legislative exercise is a serious matter. Thank you very much for your views. You have inspired us on many ideas. And so that's why we have to rethink how to construe a provision. And if there's room for improvement, we'll make the improvement. We'll listen to your views. Thank you. Now, I allow members time to ask questions about policy issues. This is actually a second meeting. And the first meeting, we also consider various policy issues. And then we see that the administration has answered many questions, even though the reply was submitted late, but I thank members for taking the time to study the reply. Now there's another document, which is the government's response to. We have less than half an hour now. Perhaps I will allow members to ask questions on bracket 03 and bracket 04. I'll allow another round of questions. So would the government take us through that paper quickly, or do we go straight to questions? The information has been provided. Perhaps we could go straight to questions. Okay, 3 minutes each. Any members, please? Or have you already asked your questions about paper bracket 03 and 04? Ms. Carmen Ken, 3 minutes. Oh, actually, you didn't take us through paper 01, you just focus on bracket 03 and the concise guide, but bracket 01 is a consolidated reply to 40 submissions. Could you take us through that quickly, please? Would you rather ask questions instead? Which particular point would you like to address? Because already in the last 2 rounds of questions, we covered almost all 3 documents. Now, bracket 01. Item 4 and item 5. Item 4, you said in determining the number of sickness days, you said you understand that the health authorities may regard the isolation order to have ended if there is negative result on day 6 and day 7. You say whether employers are allowed to check employees' leave home safe record. You said you undertook to follow up with the previous commissioner, but for 32K small b. First of all, this whole issue of vaccination, whether it's reasonable, so you first pass the buck to employers. So we have to go through the 4 steps as explained by Ms. Doreen Kwong, that is employers, we have to check those 4 steps before they could decide whether they could ask employees to provide vaccination records. Let's say if the nature of work is that there's face-to-face contact and another person, thereby exposing that person to the risk of infection, then that is a reasonable request for vaccination. Are there any job types that do not fit this criterion? That is, if you ask the employee to produce vaccination record, and then that when that employee becomes infected, he may not expose others to the risk of infection. So are there such job types really? And then for CAP 599F, you didn't. That is item 5. You didn't explain that. That is, if certain premises have to be closed because of CAP 599F, and then employers are not doing business, but then they have to pay sick leave, so they suffer loss twice. What about those cases? Can you explain that? Well, Mr. Lai asked the same question too. We have made it clear under the existing employment ordinance, if already people are not getting paid, and so when they take sick leave, they won't get sick leave pay, take sickness allowance as well. So there's the same criterion. That is, if someone is already on no pay leave, and if that person becomes infected or is subject to an isolation or order, then even if that person takes sick leave, he won't get sick leave pay. We have not changed that principle. And item 5, under section 32KB, the employer has to ascertain whether there's a chance for the employee to come into contact with others. And then if the employee is not vaccinated, then he may expose others to the risk of infection. Now, we don't have any specific examples. We believe in general circumstances, an employee probably will come into contact with co-workers or clients. Perhaps there are some examples. There are people operating a crane, and then he won't come in contact with anyone. He wears a mask throughout. He just climbs up to the car crane, it operates it, works there for 8 hours, and then he gets off work. He doesn't come into contact with anyone. And then in this case, we have for the employer to assert that if that employee doesn't get vaccinated, he may infect others. Or there are others who works in enclosed space, wearing a breathing apparatus, and that person work solo without coming into contact with any others. Then again, in such an odd circumstance, if the employer says that the employee has to get vaccinated, or else he would risk infecting others, then in such cases the employer may have to explain that. And then there may be back-end operations too. So I think it could be explained, but it's true that in certain special circumstances, maybe someone do work solo and they don't come into contact with anyone. If the employer still insists that they must get vaccinated, then well, the employers will have to explain their position. I hope my explanation has helped to offer more information to Ms. Khan. Mr. Lai Tong Kwok. I want to talk about privacy again. Let's say if an employee claims that he's been infected and so he is put on sick leave, then does the employer have the power to check the leave home safe record of employees? Perhaps there's one point we have overlooked. For leave home safe records, it's the employee who has possession of the information, not the employers. If the law gives the power to the employer, then the employer could check the records. But if the employers ask the employees to say, and the employee say, yes, you can check my record because it's nothing to do with privacy, because the data holder allows you to check the information. But if the employee won't let the employer check the record, and then the employer does not have access to the record, then again, there's no question of privacy. But it's rather, if an employer wants to check the information, but the employer is denied access to the information. So the question here is about what powers the employer have in seeking the information and how he could seek the information. And it's a matter of the law, is not so much probably about privacy. Let's say if the employer has the right to check the information, and if the employer actually checks the information, then would that be a breach of privacy? So can you respond to my points, please?
Well, the commissioner said that on the Leave Home Safe data, it will issue a joint statement with the privacy commissioner. On this basis, does the commissioner have anything to add? Nothing to add. After discussing with PTPO, I will respond to members. Mr. Lai, any other questions? I'm good. We still have around 15 minutes. Hope that we can start clause by clause. And we've discussed the policy issues. And let's start with the Chinese version of the bill. The members agree that we'll start clause by clause using the Chinese. Well, we'll look at the English version together if we not to amend the wording or any questions. And please refer to the bill CB-3-113/2022. The long title and the section 1. And for the short title, as well as the commencement clause. For other provisions, please refer to the markup copy provided by the administration. Electrical paper CB-2-192/2022-01. The legal advisor had written to the administration on the legal and the drafting aspects on 17th of March, 28th of March, and the 1st of April. CB-2-192/2022-02, 04, and 05. And urge members to take a look at the written response for the government on the letters. For example, CB-192/2022-03 and (01) and 202/2022-01, and ask the administration to explain the long title and section 1 and explain one by one, and urge the legal advisors to remind members of the legal and the drafting matters during deliberation. And members, you can use the raise hands function if you have a query on particular provision. And once we complete the scrutiny of the Chinese the bill, I ask the legal advisor to confirm that whether the bill and the drafting is secure from the perspective. After this discussion, we'll invite the administration to invite written response on the matter raised today. Well, there are 14 sections, clauses. We'll first go through the clauses of a similar nature. I might jump back and forth. How I will make sure that I will explain each clause. The long title. We're amending the employment ordinance. To regard a day which employee is subject to any restriction on movement imposed on the Prevention Control Disease Ordinance as a sickness days, and to provide sickness allowance to be paid to the affected employee under certain circumstances. And to provide that it's not a valid reason to dismiss an employee or varying the terms of the employee's contract and employment on the grounds of employee being affected employee, and to provide that it's a valid reason to dismiss an employee other than an employee that falls within a specified category, or vary the terms of the employee's contract of employment if he or she refuses to produce the proof of vaccination after a request is made by the employer, and to provide for the relevant matters. So that's the long title. And clause 1, the short title and the commencement. And this ordinance may be cited as the Employment Amendment Ordinance 2022. And for subsection clause 2, subject to subsection 3, this ordinance comes into operation on the day on which it is published in the Gazette. And subclause 3, and it was mentioned earlier, let's call it the sunset clause right now. That a few sections will be come to operation on the day appointed by the commissioner, by Gazettal. For this so-called sunset clauses, and they'll be discussed together at the final, or going through their final clause. Well, on 1(3) and 2(4) and on 6 and 11 and 14. When you come to section 14, we'll discuss the sunset clauses scenario. And for, I suppose that we can let Mr. Lai to put his question. He made a question on clause 1. Let's pause here. Well, in the paper, the government administration stresses and a few sections are governed by the so-called sunset clauses. After going through the entire bill, this sunset clause is very important to the 3 amendment items. Unfortunately, in the long title, there's no mention on this important scenario. So when can we apply the sunset clause? Just now, as the Assistant Commissioner mentioned, there's 4(2), 6, 11, and 14 sections. There will be provisions which is duplicated. Well, how did I would just say that we repeal 4(2), repeal 6, 32 KB, 68B, and Schedule 2, and etc. On how will they be repealed? By way of clause 1(3) that power the Commission of Labor to declare the commencement date. We're empowering the Labor Commissioner to repeal the 32 KB, 68D, and Schedule 11 of the power to draft legislation. This is a serious question, as we may recall that we fought the case on masking involving the Emergency Regulations Ordinance. The Chief Executive in Council, whether they had the power to invoke the ERO. Ultimately, the Court of Final Appeal decided is that it's subsidiary legislation. So long as the LegCo has the power to scrutinize and amend, then it should be fine. Well, and this provision is related to Basic Law Article 73(1). Only a LegCo has the power to repeal the constitutional powers of legislations. The commissioner already answered part of the question. The commissioner confirmed that the clause 1(3) is a subsidiary legislation. Well, the legislature will have a maximum of 49 days to conduct deliberations, including amending or repealing. And now that the format of clause 1(3), which a commissioner will repeal it by gazettal. The commissioner can repeal the provision by gazetting it. And after, and how can the legislature actually deliberate on the bill after the commissioner repeal it? This is a huge gap. So may I ask the administration, when the labor commissioner has thoroughly considered and based on the answers I just heard of all the factors cited, even though it's not explicit in this bill, however, is mentioned in the administration explanation, when it needs to gazette the date, the notice, would it delay the date by 50 days? Then the legislature will then have 49 days to scrutinize this subsidiary legislation. We're also preserving the power of the commissioner to repeal by way of notice in the Gazette. Well, I'll also have to resolve any inconsistency with the basic law or Article 73. The commissioner, please consider, if the commissioner sees it as feasible, I suppose we don't need to amend the bill either. The Secretary for Labor and Welfare only needs to, in his speech, to resume the second reading, make it explicit first that how the commissioner will invoke the power on clause 1(3). At the time of gazettal, that the commencement date will be 50 days later, which allows the legislature of 49 days to discharge its constitutional duty. It's important to have due process. In this way, that we can come to a good solution to address the sunset clause problem and to prevent any constitutional dispute arguments. We have about like 3 minutes. How about we extend by 15 minutes? We may not use up the whole time. However, I want to deal with the long title and the clause 1 and let the administration answer Mr. Lai's question. Can we agree to extend by 15 minutes? All right, thank you. Administration or Mr. Leung? Okay, I'll take the question. Thank you, Mr. Lai. Well, for the legal matters, the law draftsman can supplement. I fully agree with this. Well, by tradition, if the administration decide the commencement date on a subsidiary legislation, they will give the legislature enough time to make its own decision. Well, but it's actually more than 7 days, actually 7 legislative sittings. Well, sometimes the legislature will take on breaks. That's what we usually make sure there'll be 7 council sittings before implementation, council meetings. Well, when the secretary resumes the second reading debate, he will make it clear our position first. Then under what circumstances will the commissioner invoke his or her powers? Once his powers invoke and name a specific date, it must be longer than 7 council sittings before it comes to operation, so that the legislature has the absolute power to discharge the power under the basic law to pass or veto the bill. That's the policy bureau's response. I'll see if the DOJ would like to supplement from the legal perspective. Ms. François Lam. Mr. LD has been correct. When resuming the second reading, if the secretary promised that that only come to in operation after the entire deliberation period. And it also be promised that we submit to LegCo as promised in the future. And for Mr. Lai mentioned that there's no mention of the section 32KB in the long title of the failure to fully reflect the legislative intent. Ms. Lam? The long title usually covers the matters that need to be dealt with. We'll focus on the content. So when the provision will expire, would usually be not included in the long title.
Well, we are actually running out of time, so I won't go on to clause 2. As far as I know, the Secretariat has not received any proposed amendments from members. So can I ask if there is any other business? If not, we'll continue next time. Ms. Carmen Ken? Can I suggest this? We are talking about the long title. I think this is to sum up what this bill is to achieve. Can we put it on hold for now? Shall we just go through the whole bill and then we'll come back to see if the wordings in the long title accurately reflect the scrutiny outcome of the Bills Committee. In other words, we won't accept the long title for now. And on Schedule 11, when we go to clause by clause scoring, we will, I may propose an amendment. So are you saying that if we want to propose an amendment, we should put it in writing? Yes, if you have any proposed amendments, please give it to us as soon as possible, because then the administration needs to respond to it too. So as to whether we will come back to the long title after we complete the scrutiny bill, no, that's not how we do it usually. We'll usually start with the whole long title. Perhaps I could hold it for now. I'll give members some time, and then next time you can come back to ask more questions. So you will have time to consider the whole bill, and then you can come back to the long title. And then you could propose or suggest any amendments to the administration. So you mean we'll hold it for now? We can come back to it next time? Yes, because I don't think we have enough time now. And then perhaps you could study the entire bill, and maybe you have other suggestions, and you might want to propose any changes. Today, our meeting is mostly on the policy consideration, but we would like to start with clause by clause scrutiny too. So that's what we've done. Date of next meeting. Now, members need to give written response to questions asked. They also have to consult the privacy commissioner. So perhaps the administration could also give us the reply earlier, and then we'll then decide when to schedule the next meeting, okay? So that's the end of the meeting today. Thank you.